All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Guardianship Alternatives After 18, Legal Tools, Advocacy, and Restoration of Rights. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. If you registered, you're going to receive a copy of this recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email in the chat just in case. Also, be on the lookout since we'll be posting it on our YouTube channel as well. The training was approved by the Florida Bar for CLE. It was approved for one General CLE credit and one Juvenile Law Certification Credit. I will announce the CLE Code towards the end of the session. I will also drop it into the chat. It will also be included in the email from Zoom, and I will include it in the YouTube description as well. Closed captions are enabled for anybody who needs them, so if you're having any issues with accessibility, do not hesitate to reach out. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I will drop a link to their website into the chat so you can check it out. We have multiple subject matter work groups and some operating committees, so feel free to check it out. Membership is currently at $55, so it's probably one of the cheaper sections available for the bar. So final piece of housekeeping announcements are questions and answers. If you have questions, during the presentation, feel free to use either the chat or the Q&A. We will probably try to address all the questions towards the end of the presentation to help with the flow. If for whatever reason we see that the question is being addressed in the slide in front of us, we'll probably address that question. But as I said, feel free to use the Q&A feature so we can keep track of those questions, and we'll address questions towards the end if time permits. And that was my last item of housekeeping announcements. With all of that said, I want to introduce our speaker today, Talhia Rangel. Talhia earned her JD from Southeastern University, where she developed a passion for advocacy through moot court and clinical work, earning recognition for her service for children and families. After practicing family law, she returned to NSU as a clinical fellow and adjunct professor at the Disability Inclusion and Advocacy Law Clinic. There, she leads the Guardianship Alternatives Division, launched the clinic's annual pro bono project, and represents clients in disability-related discrimination cases. So without further ado, Talhia, the floor is yours.
Thank you. Thank you so much, Jorge. Good afternoon, everybody, and thank you for being here in this very important topic. Hopefully, you guys will find that the information shared within this presentation is going to be useful to, whatever practice you are in, and you have parents asking questions about their children with disabilities as to what happens when they turn 18. Usually, I always share my passion for this area because of my little sister. I am a big sister to a little girl with Down syndrome, and the reason why I opened my firm once I finished my clinical fellowship, it was because I still wanted to remain in this field. I wanted to continue helping parents, and the main component of my firm is hosting workshops, hosting webinars to parents and young adults with disabilities to teach them what alternatives exist out there once they turn 18. A lot of parents and students, when they are in their transition IEP meetings, are told, listen, your child is going to be 18 soon, you need to get guardianship. And, the ESC specialist, some of them are wonderful, but they're not lawyers. They don't know what alternatives are out there, if new alternatives have been implemented by the law. So speaking to an attorney who specializes in this area and can guide parents in knowing what options they have is the most essential step. So in my firm, we specialize in guardianship, mainly guardianship alternatives and restoration of rights, special needs planning, and denial of services. And the denial of services usually stems from APD, the Agency for Persons with Disabilities, when parents apply for services for their children and they are denied. Or alternatively, if they are receiving services at that time, and for some reason, those services are now suspended or terminated. So the common question that we always get is, My child is about to turn 18. What rights do I have? The simpler answer is nothing. Parents don't have rights to their children after they turn 18. So as soon as midnight strikes on their 18th birthday, they are legally recognized as an adult, despite having a disability or not being able to make decisions. This is where the parents, the family member, or a trusted individual can apply for a legal process or do certain documents to give that other person the decision-making ability. So in our firm, we always start with the least restrictive alternative, right? And the least restrictive alternative are supported decision-making. Then moving on to a more restrictive, then you have powers of attorneys, advance directive documents. Then going to a more restrictive route, you have guardian advocacy, and then guardianship being the most restrictive alternative. And we always do guardianship as a last resort, and we always try to explore the least restrictive alternatives. So the common question that every parent has when I explain that supported decision making is now a legal alternative, they ask, well, what is supported decision making? And it was enacted into law on July 1st of 2024. And if you tuned in on Friday's webinar, Disability Rights Florida was one of the biggest influencers in having supported decision making be passed into law. And essentially now it is recognized as a legal alternative that the person with the disability remains full control of their decisions, right? But they just need certain assistance when they have to decide certain things. So the way that supported decision making was implemented into law is that it was incorporated into Chapter 709. And since all of you are attorneys who are on this webinar, Chapter 709 is the power of attorney statute. So essentially, how it was written into the statute is that supported decision making is a type of power of attorney where you have the agent and you have the principal. With the biggest difference is that in a supported decision making, you cannot bind or act on behalf of the principal, right? So an example would be an 18-year-old young girl with Down syndrome wants to decide what type of credit card she wants to get, whether she wants to apply for a credit card, she wants to manage her finances. She just needs a little bit of help, right? So we can create a supported decision-making agreement saying, all of my rights remain intact. These are the areas that I need assistance in. That's why it's called supported decision making, because essentially the adult with a disability is making the decision, and the person who is the agent is the supporter. You are there to support or to not support that decision. And this is something that we see every day in our lives, but we just don't see it as a supported decision-making agreement, which is we have friends, we have family members that know about cars. So if we are in an instance that we contact one of these people and we ask, hey, this is happening with my car. I think I need to buy a new car. I'm thinking of a Toyota versus a BMW. And then the person on the other side of the phone will say, well, listen, I think Hondas are better, right? Japanese cars, they are more cost effective. The parts are cheaper. You should go with a Honda. At the end of the day, it's your choice whether you want to get a Honda or a BMW. And that's exactly the same thing when it comes to these supported decision-making agreements. It's that these young individuals can make their decisions, their rights remain intact. They just need certain individuals in their lives to assist them to get there. Now, a supported decision-making agreement, it is not a durable power of attorney, right? Which means that if this individual is one day found to be incapacitated, then that agreement will terminate. So a supported decision-making agreement is a essential tool for young individuals because it gives them that autonomy, that feel of independence, that they can still make decisions for themselves with the cushion of having someone there to assist them. And Disability Rights Florida, again, was a huge influencer in making this happen. They have created wonderful agreements for young adults to use because it can be amended to fit that individual's needs, right? One supported decision-making agreement is not going to be the same for everybody. And then moving on the spectrum of regarding restrictions or restrictiveness, you have the supported decision agreements. The more restrictive alternative would be a power of attorney or an advance directives. And these are chapters 709 and 765, where a power of attorney or a designation of healthcare surrogate or a living will, these are just writings, right, that grant authority, again, to an agent to act in the place of a principal. So the key difference here is that a power of attorney, right? The agent under a power of attorney can bind because they have that authority, the principal, in financial matters, legal matters, contractual matters. And it depends on the type of power of attorney, right? Excuse me. So you have a limited power of attorney, you have a general power of attorney, and you have a durable power of attorney. The limited power of attorney it's a type of writing that has very limited restrictions. It could be just about financial. It could be, for instance, you need to close on your home tomorrow, but there's an emergency, you need to fly out. You leave a limited power of attorney for someone to step into your shoes and attend that closing of your home. As soon as that closing happens, the power of attorney is terminated. The general power of attorney is more broad because it can include financial, property, contractual, legal matters. Now, the durable power of attorney, one second. I'm just getting over a cold. So the durable power of attorney, it's a type of power of attorney that remains valid even if that person is found to be incapacitated. No need to start a guardianship case unless that durable power of attorney does not cover everything that needs to be covered. Power of attorneys are very important for adults with disabilities because it allows for them to have support of somebody else to manage those responsibilities without the need to open a guardianship, without the need to open a guardian advocacy. So the supported decision-making agreements and powers of attorneys and advance directives, these are legal documents that do not need court intervention to begin with, right? The most important aspect is that in order for these documents to be valid is that the person with a disability needs to understand the nature and the consequences of the document that they are signing, which is why if you practice in this area and you have a parent or a young adult with a disability coming to you saying, I need a guardianship, first you have to be able to assess that person's capacity, right? And it doesn't mean they need to be able to answer all of your legal questions, but they need to have some type of understanding as to what they want to do. So these are powerful tools that allow the person with a disability to retain full control of their rights with any court intervention. Now, let's say the parent or the young individual with a disability says, well, they're unable to make any decisions, right? They cannot understand what this document says, but they're still able to do certain things on their own. That is when now you move into court interventions, where you have guardian advocacy, where you have guardianship. Now, what is guardian advocacy? Guardian advocacy, it's under Chapter 393.12, and it's a legal process where parents, family members, adults can apply to become a guardian advocate of a person with a developmental disability, right? And the person with developmental disabilities is not going to be adjudicated incapacitated, which is the biggest difference between guardianship. Now, the statute also says if the person lacks the decision ability to do some but not all of the decision-making tasks necessary to care for his person or property. Now, I highlighted some but not all because depending on what judicial circuit you practice in, guarantee you that every judge or every judicial circuit interprets guardian advocacy differently. And examples, in Broward County, you need to be able to show that the person can do activities of daily living by themselves. Are they able to eat on their own, shower by themselves, dress by themselves, groom, put on shoes? What activities of daily living can they do by themselves? If you are in Miami-Dade, for instance, the judges are looking for more complex decision-making capabilities. Can they decide who their friends are going to be? Can they make any decisions about their education? So I think right now there needs to be the same rule across the state when it comes to guardian advocacy, because depending on the county that you are in, parents are being denied guardian advocacy or young adults are being denied guardian advocacy when they are independent enough that they could do activities of daily living without any assistance. So it's important for you guys, for us to be educated in exactly what this means. And yes, everybody interprets it differently, but again, we need to make sure, what does it mean to do some but not all of the decision-making tasks? Now, not all disabilities can qualify for guardian advocacy. Under the statute, there are 7, and it includes autism, Down syndrome, intellectual disability if the IQ is lower than 70, cerebral palsy, spina bifida, Phelan-McDermott syndrome, and Prader-Willi syndrome. These are the 7 disabilities that qualified under Chapter 393.12 for guardian advocacy. Another misconception is that in a guardian advocacy, you do not need to be represented by an attorney. However, as lawyers, if we go to the statute, it says that a guardian advocate is not required to be represented by an attorney unless it is required by the court or the guardian advocate is delegated property rights, other than the right to be the representative payee for government benefits. So if you are the guardian advocate of the person in the property of a young individual, you are required to have an attorney, right? It's not that you do this process and you're not required to be represented by counsel. Also, for guardian advocacy as well, the statute says that the rules, it's all governed by Chapter 744. That if you practice in this area, you know that 744 is the guardianship statute. So there is a lot of overlap between these two, but there are some key distinctions. Now, in a guardian advocacy, I pointed out in the previous slide that the person with a disability, it's not deemed adjudicated incapacitated, which means that they retain some rights. So under Chapter 744, what are those rights that they could retain? The right to marry, to vote, to have a driver's license, to seek employment, and to personally apply for government benefits. So what are the rights that could be delegated? Is to make medical decisions, to make residential decisions, social environment, or anything regarding the social aspects of their lives, to be representative payee for SSI benefits, to sue and defend lawsuits, to sign or enter into contracts on their behalf, or to manage the property. These are all of the rights that are implemented in Chapter 744 that can overlap in Chapter 393.12 in guardian advocacy cases. Now, as I had mentioned previously, depending on what judicial circuit you are in, I have seen orders where the right to vote is removed in a guardian advocacy. The right to have employment is removed in a guardian advocacy. And I think that could be dangerous if the individual with a developmental disability is able to do those things, which is why it's extremely important to educate ourselves, especially as legal professionals, where we don't want to remove more rights than we should in a guardian advocacy. So we talked about supported decision-making agreements. We talked about powers of attorneys, advance directives, that those two do not need any court interventions. Then we talked about guardian advocacy, that it does involve the court. It is a legal process. Now we move to the most restrictive alternative, which is a guardianship. And sometimes guardianship, it is needed, right, when the person is completely and unable to manage any of their affairs. This is where the court designates an individual to make decisions on behalf of the person who is incapacitated because they lack the capacity to manage some of their properties or to meet any of their essential health and safety requirements. Now, how is a person deemed incapacitated in a guardianship? Well, you have to start an incapacity case where the court appoints 3 medical professionals, right? It is always an MD or a DO. It could be a psychiatrist, psychologist, social workers, mental health counselor. These are individuals that have been vetted and approved by the judicial circuit. And they are required to assess and evaluate the person who will be in a guardianship eventually. And they will ask questions about marriage, voting, financial contracts, legal, everything in order to make that assessment and that evaluation, right? And at the end of their report, they're going to say plenary, limited, or no guardianship. Now, what do these words mean? A plenary guardianship means it's a full guardianship where absolutely all of the rights are removed and delegated to somebody. A limited guardianship is where some of those rights were removed and delegated to a guardian. So it is very important that if you are going to file a guardianship case, that the person really is unable to manage their properties, that really are not able to meet some of their health and safety requirements. Because once that examining committee, the 3 individuals, are going to assess them, then it is their observation and their evaluation based during that assessment. Now, what rights will never be removed in a guardianship, right? Even if the person has been adjudicated incapacitated. And the rights that you see on the screen are directly from Chapter 744. Even if you are adjudicated to be incapacitated, you will retain your right to privacy, your right to have counsel, to have access to the court, to be restored to capacity if that is an option later on, to have a qualified guardian, right? To remain as independent as possible. These are the rights that are not removed in a guardianship, let alone in a guardian advocacy. So the person who is now considered a ward, these are the rights that they will retain. Now, what are the rights that are removed and what are the rights that are delegated? In the previous slide for guardian advocacy, I had mentioned that the right to marry, to vote, to personally apply for government benefits, to have a driver's license, to travel, to have a job, that those are not, should not be removed in a guardian advocacy. However, in a guardianship, because you have that layer of incapacity, these rights are at stake of being removed, right? Those individual rights could be removed, just they will not be delegated to a guardian. Now, what rights are removed and delegated to the guardian? To make residential decisions, healthcare, social environment, to be representative payee, to sue and defend lawsuits, to enter into contracts, and to manage property, right? So in a full guardianship, all the rights that you see on the screen are the rights that are removed. The ones with an asterisk are the ones that are not delegated to a guardian but are still removed. In a limited guardianship, some of these rights may be removed, right? Now, you cannot do certain things as a guardian under a guardianship without court approval, right? And this is where, unfortunately, I have had a lot of parents who are concerned that their children now are at an age where they might procreate, and they do not want their children to procreate because of their disability. Now, a lot of parents think that, oh, if I file for a guardianship or even for a guardian advocacy, I'm going to be able to make that decision on behalf of my child because I can make all of their health and mental health and all medical decisions. That is the wrong assumption, because 744 very clearly states that you cannot commit a ward to a facility without formal placement. You cannot consent on behalf of the ward to any performance of any experimental biomedical or behavioral procedure. You cannot initiate a petition for dissolution of marriage. You cannot consent on behalf of the ward to termination of their parental rights. And you cannot consent to the performance of a sterilization or abortion procedure of the ward, right? So these are very important notes to give to your clients if they are under that impression that being a guardian or a guardian advocate for medical needs means everything under the sun, right? There are limitations, there are restrictions that you need to first obtain specific authority from the court. Now, in our firm, we also specialize a lot in restoration of rights. And that's because, as I mentioned in the beginning, when the children are about to turn 18 and they are in a transition IEP meeting where they are being told, you're going to be an adult soon, meaning you're going to make all of the decisions on your own, you should get guardianship. Or mom and dad, you need to get guardianship for your son or your daughter. Then you have this family that goes to an attorney and says, I need to get guardianship. And the attorney will go ahead and start a guardianship case. Then a year later, 2 years after, because you have to continue to give updates to the court, you have parents contacting us or contacting other lawyers saying, I don't know why I have to continue to report to the court when my son and my daughter or my daughter are working and make certain decisions. Why do we have to do guardianship? And that's because you have to go through the alternatives first, right? We are encouraged to always seek the least restrictive alternatives. So restoration of rights is something that we do common when parents are not educated in this legal process and they immediately resort to guardianship. So how does restoration of rights look like in a guardian advocacy and in a guardianship? In a guardian advocacy, remember, capacity is intact. We don't deem that person to be incapacitated, so we don't need that layer of proof. So we can just ask the court to restore all the rights or certain rights that are removed. And how is that process done? In a guardian advocacy, right, you can file a suggestion for restoration of rights, asking the court to restore some or all of the rights that were previously delegated to the guardian advocate. And in this suggestion, you can file evidentiary support, which could mean letters from doctors, letters from teachers, anything that will support the need to have those rights restored. Now, the statute says that if no evidentiary support is attached to the suggestion, then automatically a hearing is going to be held. Objections could be filed within 20 days of the suggestion being served. And it's in that hearing where the judge or the magistrate will determine whether all or some of those rights could be restored. If evidentiary support is attached, then a hearing is not required. May be necessary, but it's not required. Now, in a guardianship case, because we do have that incapacity layer where the examining committees were initially appointed and they are the ones who made their assessment and evaluation, the court does say that a physician has to be appointed to examine the ward when a suggestion of capacity is filed, right? And the name of these petitions are different because in a guardianship, your capacity was removed. In a guardian advocacy, your capacity was intact. So in a guardianship, we have to ask the court to restore capacity in order for the ward to have those rights be given back. So the way that the court does it, they appoint a physician to examine the ward to see if some or all of the rights should be restored. And just like in guardian advocacy, if there are any objections, those objections have to be filed within 20 days after the service of the notice. So the key takeaways from the presentation is that guardianship should be used as a last resort. Sometimes it's what some individuals need depending on the severity of their disability, right? That you cannot explore supported decision-making agreements or powers of attorneys or even guardian advocacy sometimes because of the nature and the severity of their disability. But it should be the last resort. And us as professionals, we do have a duty to always explore the least restrictive alternatives. Unfortunately, we see that happen so often where guardianship was filed and it could have been a supported decision-making agreement, right? So if you are an attorney practicing in this area and you are exploring alternatives before you go to guardianship, but the only viable option is guardianship, always document the alternatives that were considered and why they were insufficient, right? Just so that you have it in your notes and somewhere in your files that you did explain the parent through all those options. Clients with capacity can delegate specific authorities to an agent now, and this is tied very often to estate planning, right? The reason why we do a estate plan is because we currently have capacity now. We understand the nature and the consequences of things, so we want to prevent for the future. Which is why it's very important to always talk to your clients as well. Estate planning, right? Can you do durable powers of attorneys now to prevent a guardianship from being filed in the future? And also always educate others on supported decision-making agreements. Sometimes they think that it's just a concept, but now it was enacted into law last year on July 1st. So it is recognized by the court and could be a very viable option for adults with disabilities that have some sense of autonomy and independence to make decisions for themselves. And if you have any questions about the presentation or the process, or you are taking these cases, but you have questions about the process, what needs to be filed, and again, like I mentioned, every judicial circuit is different. Please reach out. You can contact me through email. You can contact me through phone as well. And follow us on, on social media, on Instagram, where we put a lot of informational posts about guardianship alternatives APD denials if you have clients who unfortunately are going through denial of services from APD. I'd be more than happy to answer any of your questions and walk you through that process if you are interested in pursuing this area or you have parents that come in with needs. And Jorge, I think we can go for questions if there are questions.
Yes, we have a question in the Q&A. I'm going to read it out loud for the benefit of the audience. What do those formal placement proceedings look like in guardianship for commitment to a facility?
So you would have to start a 393 petition to see if you want to place a person with a disability in in an institution. But it's also under 393.
Well, that was the only question that we had pending, but if anybody wants to ask a question, it's a good time to do it. You can use the chat. You could use the Q&A feature. You could also try raising your hand and I can bring you off mute if that is a little bit easier for you. In the meantime, I'm going to drop the CLE code into the chat and I'm going to read it
There
out loud.
there is one question that says, how hard is it to get a public guardian? And in regards to this question, there are qualification barriers for parents or for anyone who wants to become a guardian or a guardian advocate. And where if there are any felonies or any convictions on the record, it is prohibited. It is a mandatory disqualification. So even if a parent has a felony conviction from when they were 18, and now fast forward, they are in their 40s because their child is about to turn 18. Unfortunately, the way that the law is written right now, it does not recognize how long ago was the conviction or the felony or the facts surrounding that offense. So to answer your question, if there is no other person who can care for the individual, the court will appoint a guardian, a public guardian. So it is very easy to get a public guardian appointed in those cases. I have also unfortunately had cases where parents have a very animosity towards one another and they are unable to make decisions together for their child. I had one case where the judge did appoint a public guardian in this case because the parents just couldn't come to an arrangement to any arrangements. Um, so in that regards, it is not difficult to get a public guardian, but if there are no willing, able, or qualified guardians or guardian advocates to step up and assist to this individual, the court will appoint a public guardian.
Right. We have a few questions in the Q&A, so I'm going to go ahead and read them out loud in order. So the first one is, can a supportive decision-making agreement coexist with guardian advocacy if a mother already has guardian advocacy or of the person for her son, could the ward still execute a supported decision-making agreement regarding finances?
If the guardian advocate, it depends how the order of the guardian advocacy it's written, right? Some some of the rights can be delegated to the guardian advocate. And if that right is not delegated to the guardian advocate and your child can make certain financial decisions, you could create a supportive decision-making agreement. Um, some of these documents can coexist with one another. It can't overlap, right? If you are the guardian advocate for financial, right, it means the court now determined that you are the person who's going to make these decisions. Having a supported decision-making agreement saying that this person retains control of their finances, they overlap, right? And they don't make sense. So you just have to make sure that the rights that are in one document don't overlap with the court order.
All right, the next question is, do you always need an attorney for guardianship? If there's a way to eliminate the attorney after certain years of guardianship, if I guess the follow-up question is there a way to eliminate the attorney after certain years of guardianship?
You can always petition the court, right, to to have for you to not be represented by counsel, and essentially it's up to the judge. But in the guardianship cases, because property rights are often, if not always, delegated to a guardian, then you are required to have an attorney. Same thing with guardian advocacy. If property rights were delegated to you, you are required to have an attorney represent you. But again, nothing prevents you from you or your attorney filing a petition to the judge and asking if they can be removed.
All right, I have two more questions in the Q&A and a few more that came in the chat, so I'm going to wrap up the Q&A ones first. The next question is, what happens when the guardian passes away? What will happen to the ward?
So in guardian advocacies and guardianships, at least in our firm, we always tell the clients, if you have another child who is over 18 with no convictions and they are willing to be appointed as a standby guardian or a standby guardian advocate, name them. Because this person, although will not have any rights or any duties to file anything while mom or dad are the guardians or the guardian advocates, at least they'll be on the core documents, right? They'll be benched, meaning that if something were to happen to the guardian or guardian advocate, they passed away, they lost capacity, or they're no longer able to serve, then this standby guardian and standby guardian advocate can step in, and now the person with a disability or the ward can now be protected.
The next question is, I recently had a court state that we needed to file an annual memorandum to the clerk form per statute 744-3678, section 5. The form asks about assets and change in assets. Does the annual plan count, which asks the same question, or is this form required to be filed separately?
I want to say that that might be Miami-Dade. Miami-Dade is one of the few counties and judicial circuits who asked for the annual memorandum, and it's apart from the annual plan, right? So you have to do your annual guardianship plans, and then you also have to do an annual memorandum where if the ward receives SSI benefits, you have to include how much they have received for that year, and file it along with the annual plan and accounting if there is accounting.
All right, so we have a few more questions in the chat. Let me mark this one as answered. So there is a comment about the public guardian, which is the public guardian is the guardian of last resort in the state of Florida. They operate in many circuits throughout the state as private nonprofits. There is case law where public guardians can deny the appointment. And there is a follow-up question on the public guardianship question. So if the only person willing to serve as a guardian has a felony, that person could still file for a guardianship or guardian advocacy and then ask the court for the appointment.
So when the guardian or the proposed guardian or the proposed guardian advocate is filing their application or their petition, they have to undergo a background check. And in this background check, that is where the court is going to determine through Florida law enforcement and national FBI records if there is any convictions, any arrests, anything on the record. And in Florida, if the person has a conviction of a felony or they pled nolo contendere to a felony that's listed on the on 744.309, then this person is automatically disqualified. I argued in front of the fourth DCA saying that guardian advocacy should be different because it's a different statute. Unfortunately, we lost in this case where the fourth DCA said guardianship and guardian advocate are identical, especially when it comes to qualifications. So it doesn't matter if it happened 30 years ago, 50 years ago, or even if this person was pardoned by a governor at one point. They are strictly prohibited from serving as a guardian advocate. So when you apply and the court finds the conviction of a felony, then you are automatically, the petition is dismissed unless you have another family member who will take your place.
There is another question related to guardian ad litem. So the question is, can a family law guardian ad litem be a guardian in your cases, or is this a different type of training? One way that I read the question is basically the difference between a guardian advocate, and a guardian ad litem.
Well, the guardian ad litem could be appointed right by the court. In guardianship cases and in guardian advocacy cases, anyone can petition the court to be appointed as a guardian or guardian advocate. So the guardian ad litem may be able to petition to the court, but I think it might be a different type of training.
And we have a follow-up comment from our friends at Disability Rights Florida. There's a link for the Disability Rights Florida site specifically on supported decision making. We've actually had webinars on this topic before, so I'll make sure to include these resources in the email. So thanks for sharing in it. And let's see, one more question in the Q&A. So to follow up, if you're already a guardian, and for some reason you get a charge or are convicted, are you then removed as a guardian?
The court, the statute says that every 5 years you have to do your fingerprints, right? So the duty is that within those 5 years, if there was a felony conviction and you are strictly prohibited. So the court may catch it immediately, right? Or when the guardian does their fingerprint, it's going to come up in their system as now they are not qualified anymore.
Right. I don't think I'm gonna double check it to see if we have any more questions. Let's see. We may have one more. Oh, who does all the verification?
Who does a verification? I assume for the fingerprints, for the background checks.
I believe so because it was a follow-up question after that.
So every judicial circuit has a specific ORI number that it's given to the proposed guardian or guardian advocate that this is where you have to go and do your fingerprints, right? In Broward County, there are specific instructions on where to get your fingerprints. Miami-Dade has different ones, but each judicial circuit has a very specific ORI number. This is a number that you'll give to the person who's doing your fingerprints, and then your fingerprints will be directly sent to the courthouse and applied to your file. So that's how the court finds out what is on your record, depending on that specific ORI number once you go and do your fingerprint and your level 2 background check.
All right. Don't see any more questions in the chat. I see a thank you for an excellent presentation. Very helpful, Talia. I'm gonna go ahead and drop the CLE code. I see a few more questions, so we'll address those questions as well. But before I forget, let me go ahead and drop the CLE code into the chat. It's 2507993N as in Nancy. So this code will also be going out via email along with a copy of the slides. I will also include the information in the YouTube description as well. So for the next question is, what resources on forms or documents could you recommend to someone who wants to start practicing in this field?
If it's guardian advocacy or guardianship, the majority of the judicial circuits now have forms and resources listed on their website, that, it provides an overview of what documents you have to file when it comes to guardian advocacy. What documents do you have to file when it comes to guardianship? So every judicial circuit, if you want to start practicing in this field, has those steps. The supported decision making, Disability Rights Florida has amazing resources when it comes to SDM agreements, and they have all the forms available or the Q&As available on SDM agreements. And then powers of attorneys, it's just, Chapter 709. You're always more than welcome to contact me if you have any questions about starting to practice in this field. I think it's really needed so that we are able to assist those young individuals who have disabilities but can still fend for themselves.
I dropped a few examples of these packets. I just Googled Florida Guardian Advocacy packet as an example, and I got a hit immediately for the 13th Circuit and the 9th Circuit. So as Talia said, just maybe Google the circuit that you're on, and you can probably find a packet, bookmark it. Same thing for guardianship. So maybe we can
Like,
eventually create a directory of all these circuits to see what they have.
yeah, and like I said, every judicial circuit is different. So if you practice in a particular judicial circuit, contact me. We offer services throughout the entire state of Florida. So usually, I already know what each judicial circuit is asking for. Because Broward, Palm Beach, Miami, Orange County, they all operate differently, unfortunately. So it really does create that discrepancy as to, well, what do I need for this judicial circuit?
All right, so there's two more questions. One of them is who arranges the 5-year check for the fingerprints? The attorney?
So if you have an attorney representing the guardian, right, which oftentimes you do, there is the order that the judge issues when they are initially appointed as guardians, and you just have to do your due diligence, right, and create those reminders that you have to do those fingerprints on the 5th year anniversary. And um, the court, depending again on which judicial circuit you are, you have to file a certain checklist that says, I have done my fingerprints.
All right, and the last question is there are there resources for guardians who cannot afford an attorney to get representation?
So that's a really good question because as I mentioned, in guardianship cases, you need to have an attorney, right? There are amazing legal aids that offer guardianship services. Now, if the person qualifies for guardian advocacy, I mentioned at the beginning that for guardian advocacy, you're not required to have an attorney unless property rights are delegated. So, my advice in this instance would be have the person be the guardian advocate of the person only. Do not ask for any property rights so that then the court doesn't come back and say you need to have an attorney represent you. That way, the guardian and the guardian advocate does not need to be forced to acquire an attorney. At least in South Florida, CABA has an amazing now pro bono department where they do represent parents in guardian advocacy cases because property rights are not delegated, so they're able to assist parents in the initial process, and then parents do it themselves.
Right, let's
CABA,
see.
the Cuban Association, no, what is it? Cuban Attorneys Bar Association. It's called CABA Pro Bono Services.
We may need to add that one to our next acronym webinar. See, the endless, they never finish. I'll find the link for the organization and include it in the materials. I tried to keep up. And I see in the chat that Bay Area Legal Services and St. Michael's in Tampa offer pro bono services in this regard as well.
That is great to know, and I'm going to go ahead and add that to my list.
Right. Let's see. I think it might be a good idea to put together eventually like a directory, like statewide directory of these are the resources when it comes to guardianship, organizations that you can reach out to. So we can share it all. We see Gulf Coast Legal Services as well. So they keep on coming.
I'm writing
And
all
yes.
down.
All right, if anybody for whatever reason if they know of any resources related to guardianship that you would like me to include in an email to all, just feel free to email me. Most of you have my email. I'm gonna drop it here in the chat just in case. Sometimes with the chat it gets lost. But let's see. I will try to do a compile list of all the
Oh my God,
organizations that provide these services so we can share it
they're all
out with
coming out.
everybody.
They're all coming out. How wonderful is that?
Oh yeah, nice. Love it. All right, so I don't see any other questions. I'm gonna go ahead and send out that email. Well, Zoom is gonna send out that email within 24 hours, so you should be seeing it tomorrow afternoon. I want to take this opportunity to thank everybody that joined us here today for this amazing webinar. And Talhia Rangel, amazing presentation. Thank you for joining us here today. We all learned a lot, and I could tell like it was a really active chat, a lot of questions, and a lot of engagement. So thank you so much for this amazing presentation. And any final words, any final comments before we wrap up?
For me, again, I just want to, thank everybody for taking the time, during your lunchtime to be present in this webinar. Please always feel free to reach out to me for any questions that you have about this field. I'm very passionate about it. And although we are a private firm, we do offer services, right, and referrals to places like Broward Legal Services, CABA Pro Bono Services, where parents are not able to afford an attorney. So again, thank you so much, and to you, Jorge, as well, for allowing me to use your platform to be able to educate others.
Of course, I see a lot of thank yous in the chat. So thank you again, Talia, and everybody that joined us. Have a great rest of your day.
Thank you.